Welcome to the Millennial Lawyer Podcast.
Hello and welcome to the Millennial Lawyer Podcast with Mark Shirian. My name is Kevin Rosenquist, and today we're going to be talking about dealing with insurance companies. We're going to talk about how to protect your rights after an accident. Mark, good to see you.
Good seeing you too.
All right. So what are some of the common tactics that an insurance company might use to minimize compensation that they offer accident victims?
Insurance companies, for the most part, they use a tactic called quick lowball offer. So if you're injured in an accident and you reach out to the insurance company, they'll be quick to offer you a very low amount in hopes that you'll just take it as quick money.
It'll sound impressive.
And it sounds like it's just and sufficient for whatever transpired.
At what point should people hire an attorney?
Immediately, ASAP, as soon as you're able to, because I understand that after injuries occur, go to the hospital, you get treatment, trauma. Sometimes you're not even able to speak to anyone. So as soon as you're able to reach out to a trusted attorney to get guidance and to evaluate whether.
How should someone approach their first conversation with an insurance adjuster after they get in an accident?
I would say that they shouldn't even have a conversation with an insurance adjuster. But if it's with respect to just reporting a claim, in car accident cases, if you're in your own car and you're in an accident and it was the other car's fault, for the most part, the no-fault insurance of the car that you're in, so it would be your no-fault insurance, that's the policy that pays for up to, usually it's up to $50,000 of your medical treatment. So that needs to be reported to your insurance company within 30 days. A no-fault application needs to be submitted. So if it's respect to just, reporting that an incident occurred and providing the location and the date and the time, as long as all that's accurate, you have a duty to report that to your own insurance, then I could understand that. But beyond that, when it comes to injuries and anything else beyond that, statements, I wouldn't delve into that.
Do you feel like even that someone may consider getting counsel first before they even make that initial call?
I would say so. Before speaking to an adjuster, I think it's imperative that you first call an attorney and present your case to an attorney. So to answer your question in a different way, attorneys' offices get calls all the time.
Sure.
So I think it's very important to, in 10 sentences or less, explain how the incident occurred and what the injuries are and where you treated and when it happened and where it happened and who may be at fault, if it's a slip and fall at a store or a sidewalk or a car accident, if you have a police report or not, or do you have any sort of documentation about how the incident occurred, gathering as much information as possible and making it as easy as possible for any attorney that you're speaking to evaluate the case. So before you speak to an adjuster from the insurance company, I would highly recommend that you speak to an attorney before doing so.
And what type of documentation or information should victims have prepared before they talk to that insurance company?
Like I said before, if it's a car accident, a police report, if it's a trip and fall, slip and fall, some sort of incident report. A lot of places, public places, have incident reports. So I think it's very important to report the incident at the time that it occurs. A lot of times I've seen, it doesn't make the case impossible, but it does make things difficult when you're litigating a case that was never reported at all. And they have no records whatsoever with respect to the incident, because it's important to report the incident at the time. So that means if it's a car accident, to call the police and make sure that a police report, an MV-104, is being generated in New York. If it's a slip and fall or trip and fall somewhere, very important to document, because what that does is it triggers the defendants to preserve evidence. If there's video, if there are witnesses, it actually puts pressure on them because they were on notice of the claim and that there's a reasonable anticipation of litigation. If there was an incident and it was reported and they're thinking of speaking to an attorney, there's a reasonable anticipation of litigation. So that puts the obligation on the defendants to preserve evidence as much as they can. So if there's no incident report and you never reported an incident, then they're under no obligation really to preserve any evidence. They'll come back and say, well, we had no idea. They never reported the incident. So We didn't go back and stop the video. We don't have records of maintenance or inspection from that day because we didn't find out about this until a year or 2 years after the incident. So it's very important to report the incident as it occurs and to get documentation of that, whether, getting a copy of that report or taking a photo of it and providing it to your attorney. I would also say on medical malpractice cases, when you're complaining about the malpractice of a doctor or a hospital or whatever it is, get a copy of those records because it will make your attorney's job a lot easier when you have those records to provide your attorney so they can evaluate whether you have a claim or not. So reporting it as soon as possible and getting that report and submitting it to the attorney so you can prove that the claim happened, the date and the time and the location, any witnesses. And a lot of times it has the name of the defendant or employees of the defendant if it's a slip or trip and fall. And that way, when you're doing depositions, those are likely the employees that you want to bring in for a deposition. So all these things are very important.
So if your recommendation, if someone's in like a slip and fall situation would be, if possible, to immediately go into the establishment or something and tell someone that it happened?
Yes, it's very important to report the claim. And you've heard this term before, but get it in writing. You've heard it. It's so true, though, because when you're talking about presenting a case, looking at the incident report, because the incident report will also have your version of the story, too. It's helpful because when time passes, you kind of forget how things happen. And you don't have
that's true.
Memory, whether it's a year ago or 2 years ago or 3 years ago, or sometimes by the time a case is filed and then there's depositions, it could be years after. And that report can refresh your recollection at a deposition or later on. So very important to put together an incident report, ask for an incident report, give your statement, and get statements from any other witnesses to make sure that the report is as accurate as possible. And that will help you along the way.
I imagine there's probably a decent amount of times where someone might have a slip and fall or something similar and not feel anything immediately and be like, it's okay, I'm fine, And then later, they're like a few days later, they're like, oh man, my back is messed up or something of that nature. Does that happen a lot?
That happens a lot. And I also hear, I understand this, but I hear this a lot, that something happened and they were so shocked by whatever it is that happened, by the incident, that they didn't think to report it. They didn't think to report the incident to anyone or the adrenaline of what occurred. They didn't feel pain at the time, but they got home and then they woke up the next day and they were in excruciating. So yes, that happens a lot and it's understandable.
Sure.
That doesn't mean it's too late to hire an attorney, send a notice of preservation, so then they could go back, whether it's within 7 days or 14 days, to preserve any sort of evidence that could still be preserved. So it does happen, and it is understandable. But again, at the moment you feel any sort of pain, it's important to speak to an attorney. But I would say that I would err on the side of caution. Whether it's not something you even think you would pursue. I think the rule of thumb is to document as much as you can, just to protect yourself in case anything comes back to you, whether it's a car accident or anything else. So even if it's not something you want to pursue or it's something that can be pursued, it is important to err on the side of caution to document as much as you can.
I imagine that sometimes people think that they can handle these sorts of things themselves, these insurance claims, not have to pay a lawyer or not have to get a lawyer involved, or just hopefully it'll be quick. Tell me why that's a bad idea. Why is that risky?
First of all, they're going to take advantage of someone that's not an attorney. Like I said before, they're going to look to lowball you.
Right.
They're going to take advantage of you. An attorney will be able to present the case in the best way, to understand the strongest legal arguments that you can make towards liability, and to counter anything that they're going to say with respect to how the incident happened and what the damages are, or how related the damages are to the incident. So I would say the biggest thing about an attorney getting involved is that, when you go through a car accident or a slip and fall or an injury, there's a lot of emotion that goes through something. You're going through a lot of emotion. When clients come to me, they're not in highest graces,
High spirits. Yeah.
They're not, when clients come to me, they're not in the highest spirits, and the emotions are high, and that makes it very hard to negotiate with an insurance company. An attorney will come in and will advocate. I definitely come in and advocate very strongly and assertively, but you do so without the emotion. And someone who's going in trying to negotiate with an insurance company is at a disadvantage because they're likely emotionally very invested in the claim, and that might hinder their ability to negotiate. And I see this with clients who are, extremely educated and sophisticated and very successful in their own careers. That doesn't necessarily translate into advocating for yourself and getting highest award. So
that's a good point. You could maybe you're a master salesman, but that doesn't mean that you can negotiate your own settlement after an accident. Yeah, that's a really good point. How do you protect clients from making statements that might hurt their case during the negotiations?
I advise them, once they're retained, not to speak to anyone without me being present. They are instructed and advised not to speak to anyone without their attorney present. It's as simple as that. So they are instructed, if they get calls from the insurance company or for the defendant or the friend of the defendant, not to speak to anyone. Because understand, if they're in a supermarket and there's a slip and fall on aisle 3, there could be friends or neighbors that shop at that store that know the owner, and things are being communicated and said. So
that's a good point.
I advise them not to speak to anyone, and that way we prevent them from saying something that they shouldn't be saying and giving statements that they shouldn't be giving. So that's one thing that we do upon being.
That's a good point. I didn't think about it even like that as I asked the question. I was thinking it more like talking to insurance companies or anyone involved in the case, but you're right. You just never know who might know someone. You could be neighbors with somebody, like you said, that you talk to, and they could be related to the store manager.
I'll also say, from what I've seen, I wouldn't tell your friends that you have a personal injury case.
Yeah.
But from my experience and being in this, New York City, whatever scene that I'm in, and the clients that I have and the scenes that they're in, clients will talk about their cases to their friends. And, unless you have to talk about your case, I would advise that the least amount of people that know about you is very important for a lot of reasons. But I think the obvious is you don't know who's supporting you or not really supporting you. And also, once the case resolves, you certainly don't want people knowing that your case resolved, because then they start asking you for money. So, and again, it goes back to the original point.
Yeah.
I think if you can keep it to your attorney and to your immediate family about your case, because it is an emotionally taxing predicament to be in, to have an attorney, and you want to talk about, the case and what's going on with the case. And
sure. And people are going to ask you questions.
People, obviously, if you're visibly injured, people are going to ask questions, and they'll ask if you have an attorney, and, people will be curious. But I would advise to tell as the least amount of people as you possibly can.
Yeah.
You never know who will talk and who becomes a witness. Because, you go to a deposition, they're going to ask you, did you speak to anyone about your case? And, then it'll come out. So,
yeah. What are some warning signs you've seen that an insurance company is trying to delay or potentially even undervalue a claim?
There are a lot of different scenarios that this comes up. We have car accident cases, and I won't name any particular insurance companies, but where there's a certain policy amount and our client liability is an absolute slam dunk. It's a rear end. They're a passenger in a car and they've had surgery. They've never had any issues to this body part before. And we're looking for the full policy on the case. And the policy on the case is, I would say, not even sufficient, but we're limited to whatever the policy is, right? And they'll lowball you, and they'll say things like, well, the injury, the surgery wasn't related to this incident, or the surgery was not, the treatment that they underwent was not necessary, nor was it related to this incident. Or they had pre-existing injuries that predated this incident, and the case is worth pennies on the dollar.
Right.
So those are a lot of, and we have to work very hard to demonstrate that the treatments that are clients undergo or directly related to this incident, or sometimes even if they had issues, even if you had prior injuries before an incident and you injure the same body part in a later incident, that does not preclude you from being awarded damages, because if there's an exasperation of a body part as a result of an accident, then that's something that has value. So those are some things that I've seen. As far as delays, I understand that the insurance companies do need time. They have a lot of claims to review claims, so that's why we always, when we make a settlement demand, we give them 30 days to respond to our demand. So those are some things that we do to make sure that the case is moving along. And if they are delaying or they're not offering us what we believe is sufficient, then we're going to file the lawsuit and litigate it to the very end.
Yeah. All right. Well, thank you for joining us on the Millennial Lawyer Podcast with Mark Shirian. If you want to get in touch with Mark, please visit ShirianPC.com. And of course, like and subscribe to the channel. We love having you be part of our audience. Mark, thanks so much for being here. It was always good to see you.
Great seeing you too. Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.